Okay, so we are recording this webinar today, but yeah, it will be posted online as a resource for other workers. So yeah, if you have any issues with that, do let me know. But yes, it will just be me speaking, I think. All right, we might get going. So firstly, welcome, and I hope you've had a fabulous Feast Festival so far. We're presenting this webinar today as part of Feast Festival, being your rights at work for LGBTIQA+ workers. My name's Kylie. I'm a lawyer here at the centre. My pronouns are she, her. So just some general housekeeping to start with. There is a chat function in which you can ask questions if you like. I'll do my best to multitask as we go to answer those. So, you know, this webinar is intended to be general information for people and isn't meant to be taken as legal advice for you and your situation. So do remember, as we go through, if you do need to seek further specialised advice on your situation, please do give us or your union a call, and we can we're here to have a chat afterwards. So like I said, I hope you can see myself and the slides, and if anyone wants to just pop a thumbs up or something in the chat so I could know, that would be handy. Great, I can see those thumbs up. Thank you very much. It's good to know. It's a bit hard when you're just speaking into the cyberspace there. So look, secondly, most importantly, I'd like to acknowledge that the land we're meeting on today is the traditional land of the Kaurna people, and that we acknowledge them as custodians of this beautiful Adelaide region. We respect their spiritual and cultural relationship with their country, and we pay our respects to their elders past and present, and we extend that respect to all Aboriginal and Torres Strait Islander peoples here today, or who may be listening to this webinar in the future as well. So navigating here. So look, just firstly, I'd like to go into a bit about who we are and what we do. We're a non-government organisation that's been operating since 1979. We're a not-for-profit. We are funded by grants from the state and federal governments and some smaller grants from unions and that kind of thing. So we provide a free and confidential service to women and vulnerable workers. So very importantly, although we've always traditionally been called the Working Women's Centre, we are funded to help vulnerable workers of all genders. So we most certainly do help men and non-binary people and all the other gender identities out there. So we don't exclude anyone, even though we are called the Working Women's Centre. And yeah, we're here to provide legal advice on workplace issues like wage theft, unlawful dismissals, discrimination, and we have a big focus on sexual harassment in the workplace at the moment. We've just gotten some specialised funding specifically for legal services to address sexual harassment. So there's the legal arm that provides that service to people who give us a call, and then there's an advocacy team as well that runs projects and helps to lobby the government to, you know, highlight and speak for change for issues that affect women and workers. And then we have an education arm as well. So kind of part of that is what we're doing here today, educating the community, but we also have fee-for-service training for businesses and other organisations that would like to learn more about how to treat their work as well. So yeah, that's a bit about us. And today's session really, it's going to be covering a few different things, I guess, from an employment law background. So, and I guess we're basing this, you know, on some of the most common calls we get from workers who identify as LGBTIQ. So we're going to be going through not only, you know, what are your fundamental rights in the workplace, but also what solutions do you have, and kind of discussing a bit about, you know, I'll definitely going through your legal options for those common issues, but sometimes, you know, it is a very difficult position to be in when you're in the workplace still. You know, how can you practically handle some of these issues that arise as well? So we'll kick off. I guess fundamentally, we all have the right to feel safe and respected at work. Um, there are laws in Australia that protect you from those kind of issues like sexual harassment, discrimination, and workplace bullying and harassment. And we'll get into those laws a bit later. But firstly, I just wanted to kind of have a moment to consider. I guess what one person can be comfortable with at work is very different to what some other person might feel comfortable at work. And I think as queer people, I'm queer myself. That that can feel different for people who've come from different experiences and backgrounds, and you might be justifiably a bit more sensitive to a comment or situation than perhaps your straight colleague might be. And of course, as well, there's different layers of intersectionality. So a workplace that's fine for a straight white person is obviously might feel very different for someone who's a queer person or a queer person of color or a non-binary person. Um, so so when we're talking about feeling safe and respected at work, there's those obvious workplace laws that are designed to protect all workers. But really, we're talking here about different layers as well. Ideally, you want to be in a workplace in which you feel safe and respected to bring your whole self to work, to not have to worry about hiding who you are or to worry about how you might be perceived or worry about expecting inappropriate comments or anything like that. So as we go through, I'll be trying to kind of, yeah, have a think about those aspects as well. So I guess to kick off with, workplace bullying is obviously a huge issue out there, and it's probably one of the most common calls we do get at the centre. Um, So I guess the legal definition is, when a person or group of people repeatedly act unreasonably towards one person or a group of workers, and that behavior is so severe that it creates a risk to that person's health or safety. But like I said, I think there's so many instances when you're at work then that you might just be feeling not quite respected, or there might be one-off comment here and there that you might feel like it has crossed the line, but it's difficult to know really when it's crossed that line into bullying and when you should actually make a complaint. Um, and I guess that really depends on you and yourself and how comfortable you are. Um, you might be feeling okay enough and supported enough in the workplace that you can let a comment slide from a coworker or perhaps address it with them directly. Or perhaps, you might not just feel secure enough to speak up about something yet. But either way, I suggest if someone says something at work and you're not quite sure what to do about it and you don't really feel like you're quite ready to make a complaint, just perhaps at least keep a note of it to yourself, just in case it does turn into one of those things that builds up bit by bit, comment by comment, and becomes a bigger issue. It's just always a good idea to have records of that kind of thing. So I guess going into some examples of things that are bullying in terms of when they have definitely crossed that line to where it's legally defined as bullying. Examples include behaving aggressively, teasing or practical jokes, pressuring someone to behave inappropriately, so real peer pressure type situations, being excluded from work-related events or even conversations in the workplace, or if it's coming from your manager, it might even be unreasonable work demands. So there's a really broad range of things that kind of fall into this legal definition of bullying, but really the key is if it's unreasonable behavior that's repeated, and it's so severe that it's creating a risk to your health and your safety. So just to flip it a bit, just to distinguish, workplace bullying isn't reasonable management action that's carried out in a reasonable way. So often it can be hard if you're feeling bullied by your manager. Um, and obviously, yes, managers do definitely bully as well, but sometimes the law basically recognize that an employer or manager, it's their job to have those hard conversations with you, to speak about your performance or disciplinary action, or to give you directions and instructions about how to do your job. So those kind of things aren't bullying, but they do have to be done in a reasonable way. So and that's a pretty grey area as well. But if you're feeling aggrieved and you feel like you're being treated differently to other workers by that manager, then it might be time to get some advice about whether that is bullying or not. So if you find that you have been bullied in the workplace, what do you do? I guess firstly, and most fundamentally, your safety is the utmost priority. If you're being bullied and you feel like the workplace is actually unsafe for you in that moment, like you're really feeling threatened, of course you've got the right to just leave and seek help. Don't ever feel like you have to stay in a place that's extremely unsafe for you. Secondly, seek support from your colleagues, your co-workers, your friends, or even your GP if it's really affecting your mental health. And once you've dealt with the immediate kind of fight or flight situation, and you're feeling able to speak about it, perhaps seek some advice, and that might be from us or your union. So again, it's always a really good idea to keep a record of what's happened, and that is really addressing the who did what did they do, when did they do it, and where did it occur. If you keep those records, I guess legally speaking, it makes for good evidence if you do have to have a claim. Also, it could be good evidence just to show your manager if you're making a complaint in your workplace about what's been going on for you, to show them that you've got those timely records of what's happened. It's not just you kind of incorrectly remembering things. Not that I think workers do that, but that's what managers might perceive. Check if your workplace has a workplace bullying policy, and if so, follow the steps in that. So yeah, if you feel safe to do so, you can make a complaint to your boss or your HR department if you're in a larger workplace. And you can directly raise the matter with the bully as well. So that might be appropriate if it's perhaps a co-worker or someone you feel that you have, you feel comfortable approaching them and have that conversation with them. So if you're going to do that, I suggest do it in a calm way, perhaps bring a co-worker as a kind of a witness to the situation in case it escalates. And perhaps that's all it needs, is that the bully might not realize what they're saying is affecting you, and they might take your feedback on board. It doesn't often happen that way, but it can happen. So those are kind of your options about how to address workplace bullying in a practical sense in the workplace. So moving on to sexual harassment, which is obviously a kind of a form of bullying, really. So sexual harassment, the legal definition is there on the slide. It's an unwelcome sexual advance or request for sexual favors, or it can be other unwelcome conduct of a sexual nature in relation to another person, which makes that person offended, humiliated, or intimidated by the behavior. So there's a lot of examples there. It can be inappropriate contact, such as unwelcome touching. It can be staring or leering. It can be jokes that are suggestive of sexual nature. It can be about your physical environments, like if there's pictures or posters, or even emails sent to you with suggestive or explicit pictures. It can be unwanted invitation for dates. That's a really common thing we get here, where the so-called professions of love type situation, where perhaps your manager or someone is continually kind of confessing their feelings to you and asking you out. That, of course, is also sexual harassment if it's connected to work and it's unwelcome. It may also be intrusive questioning about your private life or your body, or insults, taunts, or, as I said, emails or text messages. So I guess, yeah, you know, if this kind of thing is happening, obviously it's connected to work if it's in the workplace, but if it's still connected to your work, you can still have legal claims for it as well. So that might be if it's you're hanging out with your co-workers after work and your manager's there and it's more kind of a work function. It hasn't crossed that line into a completely separate private social occasion. Or even, yeah, if it's your manager who's harassing you in text or emails, outside of work on your personal devices. So that kind of thing is still workplace sexual harassment. It can also be customers or clients of your workplace as well. So we'll go into a bit more in a bit about what your workplace should be doing to protect you from those kind of customers or clients. But again, recognizing that's harassment that's occurring in the workplace. So yeah, and I think along the bullying and the sexual harassment, I guess as people who are part of the LGBTIQ plus community, I think sometimes in the broader society and sphere, our identities can be kind of sexualized in the media and everything like that. So I think it's quite common for us to be asked questions about our personal lives or our relationships, and it's it's still not appropriate. It might be coming from a place of perhaps the person is genuinely curious, like perhaps they've never even spoken to a LGBTI person before, but it really puts us in a hard place when you feel like you have to be that person who's educating someone about your identity or your lifestyle in the workplace. So I just wanted to kind of raise that it's really up to you in the moment whether you feel comfortable having those conversations with your co-workers or whoever it might be. I guess an instance I'm kind of thinking of here, a long time ago, when I was coming out at work at my first job, my manager was a bit kind of off about it at first, and he was really good in the end. Like, we actually sat down and had a conversation about it, and it turned out that he genuinely hadn't ever met a gay person before, and again, it felt really kind of weird at the time to be like, well, hi, yes, I'm gay, and it's just so strange to have to talk to your manager about that, and kind of come out to them and say, well, look, yes, I am gay. I'm not any different. I don't want to really talk to you about my personal life, my relationship, what I'm going through. However, you need to know this because I've experienced some comments in the workplace that I don't feel are appropriate. And other instances I'm thinking of is like, so I was at someone's farewell party once with a bunch of colleagues, and it was someone's retirement party, right? So it was quite a few older people there, and one of the ladies there, her husband was there, and she was kind of saying, "Oh, look, Joe, this is my colleague Kylie. She's a lesbian, like," and I'm there going, "Well, this is fun. I don't really feel like telling my whole coming out to story right here, right now to someone's husband at a farewell party." But she was coming at it from a point of view that she knew he was slightly homophobic, and she was trying to say, well, look, here's Kylie, she's normal. But it just was so uncomfortable, and I ended up leaving, honestly. I was like, I'm not in the right headspace right now to put myself out there and sit there and be this nice queer person for someone to relate to. So, look, I feel like I've gone on a bit of a tangent here, but I guess I just wanted to say, in summing up, there's a whole range of comments out there and discussions that are had, and it's really up to you in your workplace about what you feel comfortable divulging, what you feel comfortable discussing, and by no means should you feel the need to educate everyone around your identity and the broader community. And obviously I can't speak to the transgender experience, but I can imagine it must be even harder. It's such, I guess it's a even what's the word, like newer kind of topic for broader society, I guess. So I can imagine how many more questions and comments that people who are affirming their gender might receive in the workplace. And again, it's not up to you to educate everyone about that. You're there to work, and you can feel empowered to draw the line if you're uncomfortable. So I'll just move on to discrimination in the workplace, which is another really huge topic that we get a lot of calls about. Obviously, it's against the law to discriminate against workers or prospective employees on the attributes there that are protected by the law. So race, color, sex, sexual orientation, age, disability, marital status, family responsibilities, pregnancy, religion, political opinion, or national extraction or social origin. So those are the things that are protected by the law. And unfortunately, not every kind of discrimination falls under the workplace laws, but certainly in terms of sex and sexual orientation, that's very clearly protected. So discrimination can either be direct discrimination or indirect. So obviously direct indiscrimination might be not giving a promotion to someone because they're gay, or indirect discrimination might be something like where a workplace policy doesn't quite work as well for a person who's in a same-sex relationship as opposed to a person that's in a heterosexual marriage. So they're the different kinds of discrimination that can occur. So the fundamental thing is that one person cannot be treated less favorably than another person in a similar situation. And just covering as well that sexual in the Sex Discrimination Act, I think I've got a list a bit later on, but it does cover your sexual orientation, your gender identity, and your intersex status as well. So when we're talking about sex and sexual orientation, in that list, it's covering those things as well. So I thought we might discuss as well discrimination as a prospective employee. So as I said, the laws protect you against being discriminated in that context as well. So I think it's probably one of the hardest kinds of discrimination to legally prove, honestly. Like, it's very difficult if you're going for an interview to prove that you didn't get the job because of one of those protected attributes, unless the employer has been so obvious and, quite frankly, daft to specifically say something about you in one of those contexts. So, so basically, you shouldn't be asked questions directly about like your age, your marital status, your religion, if you're planning on having a family, or your pregnancy status, or any medical conditions as well, unless those medical conditions are related to the requirements of the role. So, for instance, if the job is going to involve a lot of heavy lifting, you may be asked to undertake like a medical to ascertain that you are fit and able to do that kind of work. But anything that's not related to the requirements of the role, you shouldn't be asked, and you shouldn't have to answer it. So, and I guess that's, if you are asked those questions, then really the employer is opening themselves up to the idea that your answer to that question is the basis on which they're not giving you the job. So they've discriminated against you on those things. So what you might be able to do if you're asked a question that you feel uncomfortable about. It's obviously very difficult in an interview when you want and need the job to figure out what to say in the moment. But if you're brave, you can politely decline to answer. You can bring the conversation back to the requirements of the role. So you might say something like, look, I don't think that question's quite relevant. However, let me tell you about how I'm really excellent for the job in this other related way. And honestly, I mean, if you're feeling already in the interview that they're not treating you with respect, then really it's a bit of a red flag, and you should probably consider whether you want to work there at all. So yeah, so I guess I was thinking about this because I know that, for instance, transgender people have a lot lower employment outcomes and lower earn less than the general population. Like, there's been studies that show that, which is quite unfortunate. Obviously, sorry, I just got distracted. I was admitting someone else into the chat there. But in an interview, I mean, it may be appropriate, say, to ask you what your preferred pronouns are, but it would definitely not be appropriate, for instance, to inquire further about what your gender affirmation process is. Perhaps the only way I could see something like a discussion around your identity or your sexuality might be relevant is if, say, you're going for a job in a organization that's like a LGBTIQ focused charity or something like that. Then your personal experience might be relevant to the role. But outside of that, I definitely think it's inappropriate to ask those kind of questions, and you shouldn't have to answer. So your employer really has the responsibility to create a safe workplace for you. So fundamentally, you do have the right to a safe workplace, and you should feel supported in your workplace to make a complaint if you need to. Your employer has obligations under Work Health and Safety Act and regulations to take both reasonable steps to eliminate or minimize risks associated with bullying. And, really they should be having these kind of checks and balances in place to make sure that the policies they have are working. So we'll go into a bit more in a bit about, there's actually some new laws coming out soon, hopefully, which will be placing even greater emphasis and responsibility on employers to create these kind of workplaces for us. So if you have been bullied at work, or you've been sexually harassed, or you've experienced discrimination, what should your employer do about it? As we've covered, your employer has that obligation to make a safe workplace for you, and that's both physically and mentally. So if you're complaining about a bullying instance, for example, they really need to take you seriously, listen to your complaint, and not brush it off. They should investigate it, and sooner rather than later. Timeliness is important. If it's a really small workplace and they might be conflicted out of conducting that process in a fair and reasonable way, it might be appropriate that they consider a third party to conduct that investigation. Importantly, if you've made a complaint against another worker, you shouldn't suffer the consequence for making the complaint. So often we'll get calls from people who've been stood down because they've made a complaint, and while the investigation's on, they've been sent home. That's not appropriate. So really, it should be the worker that's accused of the allegation that gets stood down with pay. Workers also need to be kept properly informed of what's going on. And if you're the person that's received the complaint against you, you need to know the particular allegations, exactly what happened, and given a fair chance to respond. So once that process has happened, the employer should decide on a reasonable and appropriate outcome. And often the person who's made the complaint doesn't feel like that's happened, and I guess that's where you can start to consider your other options for escalating that complaint. So as I mentioned, there's actually some new laws before Parliament at the moment that are progressing through the Senate. And really, they've come out of the Respect at Work report, which is all about eliminating sexual harassment and sex discrimination in the workplace. So the laws are trying to implement the recommendations of that report, which was put out by the Human Rights Commission. Yes, so the Sex Discrimination Act will be amended to introduce a positive duty on employers to take reasonable and proportionate measures to eliminate sex discrimination, including sexual harassment, as far as possible. And there will also be an express prohibition to protect people from hostile work environments on the grounds of sex. So both those things are really quite huge. Further, the Fair Work Act is being amended to specifically prohibit sexual harassment of workers, persons seeking to become workers. So if you're prospective employee, and persons conducting businesses or undertakings in a workplace. That might be a contractor who's coming in to provide a service. And it will provide for the granting of remedies when that happens. And the Fair Work Commission will also have the jurisdiction to deal with those kind of complaints. So a bit more about this positive duty. It really means that employers are going to have to take a proactive approach to preventing sexual harassment and discrimination in the workplace. So it's not enough, it won't be enough if this law passes for an employer to say, well, when my employee came to me and complained that they'd been harassed in the workplace, I took actions A, B, and C. They were fair and reasonable, therefore I'm not liable. They're really going to have to show what they proactively did to prevent the harassment taking place in the first place. Further, and in general as well, a principal can also be vicariously liable for harassment perpetrated by their employer and agent. So that's a legal way of saying that if the employer fails to prevent one employee harassing another employee, even though the director of the company didn't perpetrate that harassment themselves, they'll be vicariously liable. So they'll be responsible for the harassment that their employee did against another employee. So that vicarious liability will not stand if they can prove that they took all reasonable steps to prevent the harassment. So again, it's just coming back to the idea that it's not going to be good enough to show that they've reacted. They're really going to have to show that they've taken steps such as policies and training to prevent this kind of discrimination and harassment. And the other thing I think is really powerful, especially for our community, is the idea that there'll be this express prohibition on hostile workplaces on the grounds of sex. So it's kind of recognizing that like in an instance of harassment or bullying, in a claim, you might have to identify, person A said this, person B said that, and then the claim is against those people. But really, this will be kind of recognizing that workplaces as a whole can be hostile to someone on the grounds of their sex. So my clear, obvious example that I think of is my wife, who is a tradesperson in a male-dominated construction industry. So she's on sites, big sites with lots of your typical kind of tradie blokes. And she's not only the only gay person there, she's also the only woman. And just you can imagine the kind of things that she's had to put up with over her career. That real example of the hostile workplace. We're talking about obviously comments, things like posters in the workroom and that the breakout room and all that kind of thing. And even one example I'm thinking of right now, she said it was quite common for her to go into the lunchroom and there'll be like a table of other blokes from another trade sitting there, like literally watching porn on their phones. That kind of thing is horrendous, obviously. And I think it's just going to be really interesting to see how those industries try to stamp out that behavior. I mean, they should have obviously done it already, and I'm sure she could have had people like her could have really excellent claims under the current laws, but it's just those workplaces are really going to proactively rather, and prevent that kind of hostile workplace from even existing. So look, hopefully these laws will continue through Parliament and get passed, and then I think hopefully there's going to be some really great changes coming up in the future. So again, if you've experienced any kind of discrimination, bullying, or harassment, what can you do to protect yourself? As we've said already, make sure that you're safe and feeling supported. But yeah, if you're going to think about making a complaint, it's really important to keep any evidence you might have, like emails, texts, or screenshots of messages that you might have from your employer or colleagues. Keep a diary of conversations that you've had. And if you're making a complaint or discussing your workplace conditions with your boss, it's a good idea to put it in a text or an email if you can, just to show that, you know, that's really good evidence that that conversation occurred, and it's really hard for them to say that they didn't know about the behavior if you can show an email or a text that you've sent them about that behavior. And of course, as I keep saying throughout this whole thing, seek assistance from your GP or your mental health supports. If it's really taking a toll on you, make sure you've got those supports in place before you commence any of that kind of thing. And one really important thing to remember, it's best to get advice from us before you resign, because that can limit your options. If you resign, you may not be able to put in certain types of claims. So going on to what are your claims? So there's a number of claims that we'll go through. They can be quite complicated. So if you're thinking about any of these claims, please do feel free to give us a call and chat through. So the important thing is to get advice sooner rather than later, because some claims you've only got 21 days to file those. For instance, if you've been dismissed, a general protections claim, you've only got 21 days to file that in the Ferret Commission. So get advice quickly. The other kinds of claims you can have there are to do with bullying or stop sexual harassment orders, discrimination claims in the Human Rights Commission or the Equal Opportunity Commission, workers' comp, or even a Safe Work SA complaint. So this is just a little graph we have. Hopefully you can see it okay. In terms of discrimination on the basis of sex or sexual harassment. Again, seek advice, especially if you've been dismissed. You might only have the 21 days. But yeah, there's different options for you. So if you're still employed or you're recently dismissed, you can go to the Ferret Commission. In the other two instances, you've got either 12 or 24 months to file claims in those jurisdictions. So it's just a little bit more time. Firstly, the Stop Sexual Harassment Order. So this is where you're still working there and you've been sexually harassed or experienced bullying or sex discrimination, and you kind of want the Ferret Commission's help to mediate with your boss, basically, to stop the harassment from happening. Look, I won't go into it too much more. It's not a terribly common option, I have to say, but it can be useful if you need that help to negotiate and mediate within your workplace to stamp out the harassment, and you're otherwise happy to continue working there. General protections claims, as I said, they're where you've either been discriminated against or where you've been discriminated against, or you've raised a workplace right. And you're either still working there or you've been fired less than 21 days ago. So basically, on the left here, these are the protected grounds. So there's a workplace right and there's discrimination, which are probably the most two relevant ones for today. And then, so basically, if you raise a workplace right, like everyone has the right, say, to make a complaint or inquiry about your employment. So if you've complained about being discriminated against or not being treated the same as a straight employee, for instance, and then you suffer an adverse action, which is the things on the right here, that gives rise to a general protections claim. So it's really saying that the law provides these general protections for workers on these fundamental rights. So if you've raised a workplace right or you've suffered discrimination and you've either been dismissed, you've had your shifts cut, you've been demoted, something's happened where you've basically lost something from your employment, you've suffered a detriment, give us a call and we can chat through that option with you. But that's in the Fair Work Commission. And it can lead to compensation, it can lead to reinstatement, and yeah, it can be a bit complicated, so it's probably best to give us a call, but certainly be aware. And remember those 21 days, if there's one thing you take from this, anyone you know ever who's been dismissed from work and thinks it's unfair, please get advice within those 21 days. It's not that well known and it's terribly important. Secondly, with discrimination claims or sexual harassment claims, so there's two different jurisdictions you can go to with those kind of claims. Either the Human Rights Commission, which has a 2 years, 24 months, that changed a while ago, or 12 months in the state jurisdiction, which is the Equal Opportunity Commission. So those 12 or 24 months occur from the last incident, the last incident of harassment or discrimination, or the last in a series of acts. So if it's been going on for a period of time, then you'd take that 12 or 24 months from the last kind of significant thing that happened. The process is obviously designed to be simple and easy for a worker to lodge their own complaint. But if you're thinking of making that complaint, I do suggest it might be good to give us or your union a call to kind of go through the criteria and which jurisdiction would be best for you to lodge. So just again, when we say sex discrimination here, we're talking about discrimination on the grounds of sexual orientation, of gender identity, of intersex status, or even of marital or relationship status, so whether you're with a same-sex partner. So all of those things are covered by these claims. And of course, both those jurisdictions also deal with complaints of all the other kinds of protected attributes as well, like race and disability, etc. But yeah, today we're talking about these relevant ones. Workers' compensation is a thing that I wanted to touch on as well, because it's not often thought of in terms of psychological injuries. So I think most people think of workers' comp when, honestly, it's got a bit of a bad name sometimes, doesn't it? You think of the bloke who's pretended to hurt his back on his on the work site. But really it's there to protect a worker who has suffered an injury at work, and it can be a physical injury like hurting your back or cutting yourself or something physical that's happened to you at work, or it can be a psychological injury. So that can include things like depression, PTSD, anxiety, all those kind of things that can happen from either one really severe incident or something that's built up over a pattern of time, which is often the case with bullying or harassment. So basically, you need your GPs or psychiatrists support for this kind of claim, because it's really a medical claim. It's saying that you've received a psychological injury as a result from what's happened at work, and work needs to be the significant cause of the injury as well. So so basically, the process is you see your doctor, they fill out an extended kind of work sick certificate, and then you file it with the insurer. Like every workplace has an insurer to help them deal with these kind of claims. But the whole idea of it is that if you're successful, you'll get income and medical support to help you return to work. So that can be, weekly payments of your regular wage, and other kind of rehabilitation as well. So it might be supporting you with a graduated return to work plan, like a number of reduced hours for a while, or putting certain conditions on what kind of work you do for a while to help you get back to your regular duties. Or if it's impossible for you to go back to that workplace, it might be even involve some training to help you get a different kind of job. So again, you might like to get some further advice around that. but I just really wanted to raise your awareness that it is a possibility. So, and again, it's important that you don't resign. So the whole idea of workers' comp is that it's getting you back to work. It's rectifying the injury that occurred and getting you back to work. So if you resign, it can kind of, they call it a breach of mutuality. It's like cutting the link between you and the workplace. I mean, I perfectly understand why some people have just had enough of the bullying and whatever, have to get out there, want to quit. And I totally get that. But like I said before, it's better to get advice before you quit, because this might be a better option for you rather than just quitting. It might give you that income and support to get better while rather than just quitting. Creating change in the workplace. So I guess just before we move on, I just wanted to say as well that I have gone into quite a lot of detail about your legal options for these kind of issues. And I just wanted to say, it really does take time for people to process these kind of things at work. And I guess it's my job here today to raise awareness of these kind of issues. But I also wanted to say these options aren't for everyone. And I do also recognize that going through a legal process can put a lot of stress on people as well. It's not for everyone. And sometimes you just, need some space and time to process before you consider whether any of these claims are right for you. But I guess the real message is seek some advice, be mindful of the timeframes, but do seek the advice, especially before you resign. And if you decide after getting that advice that these kind of options aren't for you, then that's completely fine as well. So yes, getting back to creating change, the more positive kind of last part of the webinar here today. So look, I did a similar webinar to this last year, and even since then, there's been some new changes around best practices in the workplace. There's new laws being introduced. So I wanted to cover some of those new laws and also give you a few tips around how you can create change in your workplace as well. So firstly, gender affirmation leave has been in the media a bit this year. There's been a lot of big companies like ANZ, Woolworths, Accor, Allianz, to name a few, and the government departments as well, that have introduced this kind of leave. So really it's recognising that transgender and gender diverse people are more likely to experience lower incomes and employment rates. And they shouldn't have to exhaust your annual or sick leave if you're going through a gender affirmation process. So the idea is that this leave is available for to help you through that process, like social changes, like adopting the dress and style of presentation that better aligns with your identity, and changing your pronouns. Could be time off to deal with legally changing your name or gender on your ID documents, or if you're receiving medical treatment as well, like hormone therapy or surgery, going to those kind of appointments or recovering from those kind of medical procedures, that would all be covered by this leave as well. So it's a really fantastic thing, and hopefully more and more companies do take it on board. Just as an indication, these new policies are ranging from anywhere from 10 days paid leave up to 6 weeks paid leave, and 12 months unpaid leave to help employees through these processes, as well as other supports like employee assistance programs, and policies and guides for managers and workplaces to help the employee go through this process as smoothly as possible. So if you're working for a bigger workplace, it might be a good idea to check your workplace policies or your enterprise agreement to see if you've already got that kind of leave. And if you don't, I guess, look, I really hope it does become more part of the standard suite of entitlements for workers. But if you don't, there's nothing to stop you from trying to negotiate that kind of leave with your employer. You may be able to take some kind of unpaid personal leave, for instance. Obviously, it's not as good as paid leave, but talk to your managers and tell them what you need. And again, remember that you've got the right to make a complaint or inquiry with regard to your employment. So it would be, I can't even imagine, honestly, it would be quite difficult to have those conversations. But just remember that by doing so, the law has got your back, and your manager or workplace can't take adverse action against you. They can't fire you, they can't cut your shifts simply because you've raised these kind of requests or inquiries with them. So just another kind of leave I just wanted to highlight quickly, which is more relevant to all workers, not just LGBTIQ community workers. But there's a new kind of family and domestic violence leave available to workers. So before the new laws, well, currently actually, workers are entitled to 5 days of unpaid leave if you're experiencing family or domestic violence. But from the 1st of February next year for large businesses, or the 1st of August next year for small businesses, all employees will be able to access 10 days of paid leave. So that's full-time, part-time, and casual employees. And it's pretty big news, honestly, because it won't be prorated for part-time or casual employees, and it's available up front, so you don't have to work there for a certain time to accrue that leave. So it's quite significant change in leave, especially for casual employees who previously weren't entitled to paid leave. And I just wanted to raise that because yeah, I understand that there's research that's been done that family domestic violence is kind of unreported in the LGBTIQ plus community. But this leave is available here for you if you do need it. And if you need advice about that leave or negotiating it with your workplace, then of course give us a call. I also wanted to briefly mention, this only popped up in the media for me today, but there's a new push for menstrual leave, which affects obviously all people that menstruate. So there's calls for employees who have painful periods or menopause symptoms to have leave, 1 day a month or 12 days a year of paid leave. So several unions have started surveying their members about this. I just wanted to mention it because it's another thing that you can, start to have conversations with your colleagues or co-workers, or even, your workplace, perhaps if you've got a progressive workplace that might be receptive to that kind of conversation. So I just I've got a link there to the ABC News article. You can have a read of the article if you like. But yeah, and there's a model policy there as well. So we'll include things like working from home, or having a rest, or taking that day's leave. So again, I just wanted to raise that as something new that might be happening, and maybe by this time next year I'll be talking about how this has come into effect as well. I mean, we can hope. But I guess my point is, you've got the power to create change in your workplace. I know that's very easy to say, but it really starts at the bottom by you having conversations with your co-workers. And there's power in numbers. If you get enough co-workers on board that you have a big group to approach your management with these kind of ideas, you never know, they might be willing to consider making changes to your workplace. So talk to your co-workers, or ask your employers about policies, and encourage them to develop those policies. Like, you can even talk to them about this new positive duty that will be coming into effect, that it's going to be very important for them to have these kind of policies to deal with sexual harassment and to have that safe workplace for you. And in terms of bullying or harassment, raise any safety concerns you might have. And even theoretically say, like, hey, look, if I have a customer come into work and I feel uncomfortable, or perhaps they say something to me, like, how would you prefer that I deal with that situation? Just have those conversations with them, so you know what to do, and they've been forced to turn their mind to it as well. I also wanted to very briefly mention this idea about being an active bystander. All that really means is having your co-workers' backs, really. By standing up and speaking out if you witness poor behaviour in your workplace, you're not only discouraging the perpetrator of the bullying or harassment, but you're also supporting the victim in that situation. So it helps to not only stand up for your co-worker, but over time improve the culture of your workplace. So you can either stand up in the moment and speak out, or you can report that behaviour. Yeah, and just finally, keep up to date with initiatives you're in your industry. Like for instance, I did a webinar a few weeks ago with Not So Hospitable, who are really calling for change in the hospitality industry. So join those movements, join your union, and try and collaborate with your co-workers to make a difference. As we're coming to the end, just some further resources for you. We've got some resources and fact sheets there around sexual harassment and at work, and on what your options are. As I said, we're always here if you do need a call for some advice. We've kind of run out of time we don't have a lot of time, but if anyone did have any questions or comments, I would love to answer those for you. I know it's been a lot to bring in to talk about. I have gone into quite some detail about the legal options you have. And again, I just really wanted to raise your awareness of those so that you are empowered and have that knowledge to seek further information if you need. But just, I guess, as a final message, yeah, look, I'm really happy to have had this opportunity, especially as part of Feast Festival, to share this information with you. I really do hope year by year that this kind of thing becomes less and less necessary. Look, I'm not quite that rosy, starry-eyed rather to think that that's going to be reality for us anytime soon. But like I said, even since I did this similar webinar last year, there's been change. So I really do hope that yeah, we all have supportive and respectful workplaces. And certainly if you don't, please do reach out and give us a call for some advice. So yeah, please do follow us on the socials and all that. We do hold these webinars now and then. We'd love to see you on those platforms. Stay in touch and support us, and tell your friends around us, because we are really here to try and help workers like yourselves. So without further ado, thank you so much to everyone for attending today. I hope you've found this useful, and please do reach out if you'd like to speak with us further. Thank you so much. And I hope you have a fabulous rest of Feast.